Hi, everyone. Welcome back once again to the SIAC COVID-19 webinar series. My name is Pauline Lau. I am an Associate Counsel at the SIAC, and I'll be moderating today's session. Now, for those of you who are joining us for the first time in this series of webinar, we discuss current arbitration issues in the times of COVID-19. Now, we do want to keep this session as lively and as interactive as possible. So if you have any questions at all, please send them to us using the Q&A function below, and we'll get our panelists to answer your hot and burning questions. Now, the topic we are looking at today is interim measures, and we'll be looking specifically at emergency arbitrator proceedings. And we thought that this would be a topic that is relevant and would be of interest to many for at least two reasons. Firstly, we do see an increase in the number of EA cases filed with the SIAC. We have just received our 101 case, EA case filed with the SIAC, 7 of which were filed this year and 3 after the COVID-19 breakout. And of course, naturally now more than ever in the times of COVID-19, there will be questions like, okay, so because of the COVID-19, my business has now stopped. And parties that I transact with are now coming at me from various different directions, and I desperately, urgently need to maintain status quo, and at least until June in Singapore. What can I do? And this is just an example of a situation that people may find themselves in the times of COVID-19. Now, to shed light on this, we have with us today 3 individuals who have probably sat as EA more times than anyone else. They are Professor Benjamin Hughes, Professor Kim Joongi, and Mr. Gaëtan Verhoosel. And so I thought before we start, perhaps I could get each of our panelists to take a couple of minutes to share with you their experience with EA. Maybe we can start with you first, Ben. If you have been appointed as an EA the number of times and under how many different sets of institutional rules. No requirement to mention the names of the institution, of course.
Well, thank you very much, Pauline, for having this event and for having me join. Yeah, I've done maybe about 10 emergency arbitrations, and I've done them under the rules of SIAC, of course, and also the ICC and the HKIAC. So I really enjoy them.
Joongi, what about you?
I haven't done as many as Ben, but I'd like to share an interesting story I had. My first time I was contacted to serve as an EA, it was actually by SIAC, and I was actually traveling. And it was my first opportunity, but I was traveling, so I just said, missed opportunity, so I had to turn it down. 2 days later, I get an email from actually the co-arbitrators in the exact same case asking me to serve as chair of the case. And I was like, what are the chances of that happening? And then luckily I was able to serve on that. So I guess that case was kind of destined for me in some ways. I'll get back to that story later.
We will indeed get back to that story later. And Gaëtan, what about you?
Yeah, so I'll be able to share a couple of stories as well, because in the few EA cases that I had to do, both as the EA and as counsel, I had the good fortune of the decisions in question being leaked. So I'll be able to talk a little bit about that. I think when you have both a counsel and an arbitrator practice, accepting EA appointments is often for people a little bit more challenging, because I think, as we all know, it really does require you to clear your schedule for the next 2 weeks, and sometimes it's possible, but sometimes it isn't, and that's maybe something we can talk about a bit later.
All right. So thank you all very much for the brief introduction. And I see right now we have already over 900 participants with us. For those of you who are maybe more familiar with court injunction, I thought, fret not, we are going to start with some background questions on emergency arbitration generally before we move on to more COVID-19 specific issues. And I thought what better way to start than to ask the question, and this is to Joongi. Who is an emergency arbitrator and what are his powers?
Okay, just to give you a short crash course in what we call an EA is, your typical arbitrator, of course, is appointed and serves sometimes a gloriously long time, which can be a couple of years sometimes. But your EA typically has a very short lifespan. And of course, in the case of SIAC, it's a maximum of 14 days. So after 14 days, they're gone. So the EA is to serve a function to fill in the gap before the tribunal is constituted, because that takes time after you file your request for arbitration. So that can take several weeks, sometimes even months. So then there's a gap and you need someone to fill the gap. Sometimes, of course, a party can go to the court, but they've developed this institution called an EA to potentially provide interim measures, usually for things like preserving property or assets or evidence. To get back to my story that I was telling you about before, in that case, later on, we had a very tricky privilege question that came up. One side was asking that a document was privileged, the other side was challenged it was not privileged, and we were trying to figure out what to do. And then it just dawned upon me that we had a very prominent Singapore counsel who actually served as EA because I couldn't serve. So we asked him to serve as the person that would review. We kind of resurrected him. He wasn't as an EA capacity, but because he was a neutral person and everybody agreed. And he actually kind of reviewed our privilege questions. So EAs can serve things beyond what you normally think.
Right, absolutely, Joongi. And as you mentioned, the emergency arbitration procedure, really what it is at its core as a mechanism to preserve the status quo prior to the constitution of the tribunal. And absent that, if you really think about it, parties are probably left with two choices. A party could either wait until after the after the tribunal is constituted, depending on the urgency of the case, or B, a party could go and approach the courts. Now, there are obviously tactical and strategical reasons why a party may choose one over the other. And this leads me to my next question for Gaëtan. How much forum shopping is possible for parties seeking an urgent interim relief? And what would you say is the interaction between the courts and the EA provisions?
Yeah, so in short, I don't think there's that much scope for what you refer to as forum shopping. Your options are 1, an emergency arbitrator or the arbitral tribunal, 2, the courts of the seat, or 3, the courts in which the relevant assets, evidence, or parties are located. Now, to which one of these forums you take your application will depend on any number of considerations specific to each case, including the nature of the relief sought, its effectiveness, and its enforceability. For example, if you need an ex parte freezing order against third parties, then clearly you won't go to an EA or the tribunal. Most EA rules do not provide for ex parte applications, and arbitrators, of course, cannot bind third parties, so court is then the only fertile forum for those kinds of applications. And that, of course, is assuming that in the current COVID era, the courts in questions are in fact operationally able to hear the application quickly enough, an assumption that obviously shouldn't be made lightly. Another point that I think shouldn't be assumed lightly is that the courts in question, even if today they are operationally able to process an emergency application quickly enough, whether they will grant the interim relief where the applicant can obtain that same relief from an arbitrator, whether that's an EA or the arbitral tribunal. I think as arbitration practitioners, we often assume as much, but it's not necessarily the case. If you take, for instance, England jurisdiction where I practice, there the High Court held in the Gerald Metals case, which was in 2016, that the court can provide interim relief in aid of arbitration under Section 44 of the Arbitration Act only where an EA or the arbitral tribunal is unable to do so. Now, in that case, the LCA had denied the application to appoint an EA, and the High Court, when presented with an application for the same interim relief, rejected the application on the basis that the court could only provide such relief where the powers of the EA were, and I quote, inadequate, or where the practical ability is lacking to exercise these powers. No doubt this will be different in different jurisdictions. Some jurisdictions may not have a similar role. Others may simply afford discretion to the court, and others will have neither. But it is perhaps an obvious point to interrogate in each case before filing the application in court, either in parallel with or in lieu of an EA application.
Okay, thank you very much, Gaëtan. And I think also from a timing standpoint as well, I think one of the advantage of filing an EA case with the SIAC is that you can do it on a Friday after close of business, have the EA appointed on Saturday morning. I see some smiles there. I know that many of you here, panelists, can relate to that immediately. Have the hearing done over the weekend and the relief granted by Monday morning. Speaking of timelines, I'm now turning to you, Ben, and only because of the sheer number of times you have been appointed as EA, maybe you could give us an idea of what the timeline and structure of a typical EA proceedings would be like.
Okay, sure. Well, just to echo first Gaëtan's point, the same is true in Singapore. The court will not provide interim relief if the if the tribunal or the arbitral institution is able to do so. And so I think it's very important. Within Singapore, forum shopping is very limited. In terms of the timeline, it is extremely short. And if you see in the SIAC rules in Schedule 1, paragraph 9, it will say that you have 14 days. And without intending to give offense to SIAC, that is not true, because you actually have to build in time also for SIAC to conduct what we call a mini scrutiny. So you really have to give that award to SIAC, I think, before 14 days. So it's a very, very tight timeline. Paragraph 7 of Schedule 1 requires that the emergency arbitrator establish a schedule for the emergency arbitrator proceedings within 2 days of appointment. And I think that in practice, that happens actually much more quickly. As soon as someone is appointed, they immediately will reach out to the parties and try to set up a quick call, case management conference, call it what you will, to set the timetable. And typically what's involved in the timetable is that the respondent must be given an opportunity, obviously, to respond to the application. Often the respondent is caught a bit unawares because suddenly they've been served with this emergency arbitrator application that the claimant has had maybe a little bit more time to prepare. And then if time permits, there'll also be a rejoinder from the claimant. And then you move to a hearing if necessary. And normally, in most of my emergency cases, there have been hearings. There is time for this, and I think it's very useful. It can happen by telephone. It can happen by video conference. I've had some cases in which the parties preferred that I fly to the jurisdiction in question and conduct a full day hearing on the matter because it was something that was so important to them. And we can't rule out that sometimes the interim relief will have a dramatic impact on the conduct of the case going forward. In some cases will lead to a settlement. And then, so after this hearing takes place, in a normal arbitration, you might have post-hearing briefs, but this is something that is, again, decided on a case-by-case basis, given the short timeline. I find it actually useful in some cases because, again, the hearing has happened in a very expedited manner, and the counsel may not have had time to prepare everything and get everything into those submissions. And there are specific issues sometimes that are identified at the hearing that the parties are able to clarify in written submissions immediately after the hearing. So maybe a day after the hearing, parties can submit these post-hearing briefs, but they're very short, they're very specific usually. And then the tribunal, the emergency arbitrator, who is not the tribunal, writes the order or the award and submits it to SIAC for scrutiny. In my experience, SIAC has been incredibly efficient in doing this scrutiny. The turnaround is very fast. And I remember the first EA case I did with SIAC, I think we got the award issued in 6 days. Sometimes you need the whole 14 days, but sometimes the parties are, something is very, very urgent. They want to answer very quickly. And if I recall correctly, I gave the draft to SIAC on Saturday night. On Sunday morning, they had it back to me with their comments. And so I was very impressed with that. And we issued the award on that, I think on that Sunday. So it's an incredibly tight frame to work in. But I really enjoy these. It's somebody said it's like arbitration on methamphetamines. No one gets to sleep. Everyone's very jittery and tense. But I think it does provide a very valuable service.
Right. Thank you very much, Ben, for that. And again, Ben, this question is also to you. I'm now turning to standards. Would you say that there is an international standard for the grant of interim relief? I mean, we see parties, citing Article 7 of the model law, American cyanamide, balance of convenience, irreparable harm. But what do these all mean to you as an emergency arbitrator? Maybe you could, what would be your standard when deciding whether or not to grant an interim relief?
Yeah, you broke up a little bit, but I think I got the question, the standards that are applicable to granting an interim measure in emergency arbitration. Parties will reference the standards for interim relief in their submissions, and that is a good place to start. And I think it's very relevant to the work that the emergency arbitrator is doing, because it is, after all, an interim measure. But there are a few differences. You'll all be familiar with the sort of formulation that's in the model law that I think is similar in many jurisdictions. The party that's seeking the interim measure has to show harm not adequately reparable by an award of damages is likely if the interim measure is not ordered, and that harm outweighs the harm that would be visited upon the other party if the interim measure is ordered. And then the reasonable possibility of success on the merits of the case. To that, I would add urgency, first of all. And in this context, I mean, urgency is often regarded as a necessary element for an interim measure. But in this context, the question is, can the interim measure that you are seeking wait for the constitution of the arbitral tribunal? As much as I enjoy doing emergency arbitrator cases, obviously it's ideal to have the tribunal decide these issues if possible. And so, is this something that is so urgent that you cannot wait for the constitution of the tribunal? And that it goes to the question of the admissibility of the application, I think explicitly so under the ICC rules, but implicitly so in other rules. Then you come to the next test, which is the balance of harms test. And I think that's also very important to do. And then the reasonable possibility of success on the merits. Now, you get a lot of debate about how far an emergency arbitrator or an arbitral tribunal, for that matter, should go in assessing the merits of the case in the context of an application for interim relief. And there's always this caution that you shouldn't prejudge the merits of the case. But I think that caution is somewhat reduced. I mean, that concern is somewhat reduced when you're dealing with an emergency arbitrator, because that emergency arbitrator will not be the person who is deciding the case on the merits. And so it is necessary, I think, in order to make a commercially reasonable decision, pending whatever the arbitral tribunal is going to do, to really assess the merits of the case and decide whether this interim measure should be granted, because you don't want to protect a party who ultimately has a very weak case. You don't want to order measures against a party who ultimately will prevail. I mean, there are other, I think we'll come to this later, there are other measures you can take to protect people when they do have an interim measure ordered against them. But I think it's very important for the emergency arbitrator to look into the merits of the case on this prima facie level and decide whether there is a realistic probability of success on the merits in deciding whether they will grant the measure.
Right. Right. So thank you very much for that, Ben. Now, I want to now turn to costs, and under the SIAC 2013 rules, the emergency arbitrator shall apportion costs, but under the 2016 rules, the emergency arbitrator may apportion costs. Now, this question is for Joongi and somewhat related to what Ben has just said also. In your experience, would the question of costs be better dealt with by the emergency arbitrator, or do you think this is something that should be best left to the tribunal after it has been constituted? And Joongi, we do have one question for you related to this also from our participants. How much is the EA influenced by the fact that a tribunal will deal with the matter later, and thus likely to give way to the emergency request?
Thank you, Pauline. I think that's a really interesting question that it comes up a lot. So the question, of course, is, as I mentioned earlier, the life of an EA is very short. And once the tribunal is constituted, the EA actually is no longer around. So the question then is, you know, should the EA defer on the cost issue? Because actually, once the tribunal is constituted, the tribunal can undo everything and revisit everything that the EA has done anyways, whether it's an order or it's an award, whatever they've decided, they can undo it or modify it or do whatever they want, which probably, of course, would include costs. So at the end of the day, the tribunal has basically absolute authority. So then should the EA, in that circumstances, just kind of defer, make a decision, but defer the issue on cost? Because of course, ultimately, the tribunal will make a decision on costs, which will include what the EA has decided upon. So I guess there's two very strong schools of thought. And I tend to view that it is helpful, I think, for the EA to provide some guidance for the tribunal. Of course, the tribunal can totally disregard it, but after EA has made a decision, then the tribunal will have someone who's done a preliminary review, was hands-on, saw everything that was going on, and they can factor that into their decision. Because once the EA is gone, it's not really easy for the tribunal to go ask the EA questions and so forth. And the other tricky issue that comes up, and I think this is good practice to keep in mind for counsel. And the issue is, because it's, as Ben mentioned, it's a really hyper atmosphere of what's going on. What happens is that counsel, of course, they're really worked up and arguing the merits, and a lot of times they don't focus a lot on costs. And what they do is they'll just basically have a general statement on costs. I would recommend, in my view, it's probably better, I would think, that counsel should try to offer some type of an estimate on costs. Because if you don't offer any estimate, then basically the EA would have to just say, give a general statement that either costs follow events or break down some type of percentage, but they can't really fix an absolute number because there was no numbers offered by the parties, because you don't have post-hearing briefs or you don't have separate cost submissions after that. Basically, you're already done, proof everything's over with. So that's something I think counsel should consider.
Thank you very much, Joongi. And sorry, yes, Ben?
Sorry, I just wanted to make a quick comment on the cost, because in almost all of my cases, the parties have agreed to defer this issue for decision by the tribunal once constituted. And I think that makes a great deal of sense because, again, as Joongi mentioned, you have a very short time to do this, and cost submissions would be, I think, difficult to handle. But also, let's say, the tribunal once appointed has the power to revisit this interim measure. And let's say that the emergency arbitrator awarded costs to one party, and then the tribunal, once constituted, then comes back and undoes the measure. So I think it does make sense in a way to have this issue of costs decided by the tribunal once constituted.
Oh yeah, I don't disagree with that. I just think it's helpful to the first point you mentioned, yeah. If the parties agree to defer, that makes life easier. But I've had cases where the parties don't agree on that. And then the second point, of course, is I think it's helpful that the tribunal just has some number as opposed to no number. That's just my personal view. Of course, they're totally up to them to disregard it and use it to their discretion as they want.
Right. So I think we do agree that there are a few considerations. Of course, whether the parties want to submit, whether time permits. It is clear that the EA has the power to deal with costs. Now, Ben, I'm turning to you again. Under the SIAC rules, the emergency arbitrator has the power to order an award to be conditioned upon the provision of adequate securities. Now, how would this affect your decision on whether to grant interim relief or not, and in what circumstances might this arise?
Well, I think granting of security, the purpose of that, requiring the provision of security, is to protect the party that is having the interim measure ordered against them. And in some cases, you may condition the relief that you're ordering on the provision of a security in order to provide that protection. For example, if the measure is, remember the tribunal has the power not only to order you not to do something, but also to order you to do something. To continue, for example, performing under a contract, or to provide some service or to provide some good, etc. To allow the continued use of licensed technology. And so it may make sense in the context of some of that relief, in particular where there's a financial element. So in a recent case, for example, there was, the relief was requested was to prevent calling on a performance bond. Now the performance bond would expire in the meantime, and so it actually happened. The parties on both sides were very reasonable. The party that was seeking the interim measure agreed to keep that performance bond in place until the issue was resolved by the tribunal. And so, but that's something that maybe the emergency arbitrator would have ordered, even had the parties not agreed, because one party is saying that they have the right to call on this bond, and the other party is saying that they don't. Well, if in the meantime, the party that is seeking this interim measure then is able to allow that bond to expire and the interim measure becomes a permanent problem, then that wouldn't, I don't think, be appropriate. Maintaining the status quo goes both ways. So I think there are numerous circumstances under which you might consider ordering the provision of security as a condition for the relief that's being requested.
Right, thanks, Ben. Now we are almost 30 minutes in, and I think we have covered quite a number of key points on emergency arbitration generally. But before I move on to more COVID-19 centric questions, let's talk about the use of emergency arbitration, as a strategic and tactical tool. Now, at the SIAC, we know and we have seen how the EA application can, a lot of times, result in an early settlement of a dispute. And Gaëtan, I wonder if you have any views on this, how a party can tactically and strategically use the EA proceedings.
Yeah, sure. And it may be useful to sort of define what we understand by tactical or strategic use. I don't think any application for urgent interim relief should be pursued lightly, or in the absence of at least an arguable case the need for relief. But if the question is whether broader strategic considerations may inform the decision to pursue an EA application, then I do think that that clearly is the case. First, parties may launch an EA application in the hope that it will pressure the other side into changing its conduct. And I've seen, and I'm sure many of the colleagues who are watching this have had the same experience, I've seen how the mere fact of launching the EA proceeding can sometimes cause the other side to either temper or even forego whatever self-help they had been threatening with, and thereby render the application moot. And I think that's it's an important point because it shows there's value just in the availability of the EA mechanism. But as you indicated, parties may also pursue an application in the hope that it will facilitate a negotiated solution of the dispute itself. And there too, in my own practice, and I'm sure others have similar anecdotal experience, I've seen when the EA's decision had the effect of preserving the applicant's bargaining power, or when it dropped some heavy hints regarding the merits of the claim, that the case did indeed settle shortly thereafter. And again, I think that shows there's value in the mechanism. And I said I was going to share maybe one story. In a case against a state where my client alleged a denial of justice by the courts of that state, the emergency arbitrators award granting an injunction against the enforcement of the offensive court decision in question described that court decision in the prima facie case section of the award as, and I quote, an abdication of procedural even-handedness and legal methodology and grotesquely flawed. So you can imagine that where the claim is one of denial of justice, when that EA award is handed down, it does make one of the two sides think again, and indeed in that case, we achieved a settlement shortly after the award came out, the EA award.
Right, that's a very interesting story there, Gaëtan. And just before we move on, if I can just ask you one final practical question. Now we know that Singapore has provided for the enforceability of EA awards in Singapore-seated and foreign-seated arbitrations. But so what do you do if you have to take that EA award out of the jurisdiction? And assuming no voluntary compliance, how are EA orders or awards enforced? And what does a party do in the case of non-compliance?
Right. Well, you know, the premise of your question was, what if there's no voluntary compliance? And that's an important premise, right? Because I think the data, to the extent they're available, and the ICC task force report collected quite a few of those, suggested in the vast majority of cases there is voluntary compliance, right? And for good reason, because if you don't comply, you know that there will be an opportunity for the other side to present a narrative before the arbitral tribunal later on that the non-complying party shows a certain propensity to breach its obligations, which is a narrative which normally you would want to avoid. But in cases where there's no voluntary compliance, I think the reality is that enforcement becomes quite unpredictable. You gave the example of Singapore, which has provided for express provisions enabling the enforcement of EA decisions. But as you know, that's only one of, you know, a few jurisdictions in the world that have done the same thing. So if you have to actually enforce an EA decision, whether it's presented as an order or an award, you're going to have to navigate the difficulty of establishing that you meet the requirement of finality. And there, you know, EA is still relatively young. There are not that many decisions. You probably all know that in the US, there's been a few decisions that have enforced EA decisions as if they were interim awards. But that's by no means true as a general proposition. So in many instances, you are looking at considerable unpredictability. Some have suggested that the specter of the possibility of a damages claim later on before the arbitral tribunal for breach of the obligation to comply with the EA decision could help. My own view is that that is sort of easily overstated. I think that's not necessarily a great deterrent, and I think that kind of damages claim is often priced into the non-complying party's decision not to comply. So I don't have a good answer for you as to how you can ensure seamless and quick enforcement where there's no voluntary compliance. But I do think that is still the state of affairs today.
Right, so now that we all have a good idea of what an EA application is and how it can be made, let's move on to more COVID-19 centric issues. And we know that there may be times when urgent interim relief is required, but Joongi, based on your assessment of the general state of play right now, do you think that this need will be more heightened than usual?
I think the need would be more heightened, and I think one of the, of course, bizarre kind of unexpected silver linings of COVID-19 is, of course, I think for arbitration, we've made a kind of a quantum leap in terms of breaking through that resistance in terms of technology. And of course, in the past, we probably would have conducted most EAs by telephone conference, if anything. But now I think everyone's becoming very comfortable. Even our most seasoned arbitrators are being very comfortable with technology and figuring out how WebEx and Zoom works. I think that I was trying to figure out what, my view is that the EA under COVID-19 is what I would call not AR, but AU in terms of augmented urgency. So everything is much more urgent now under COVID-19, and it goes both ways. I think it goes for the applicant, things can be much more urgent, and also for the respondent as well. The applicant can plead that they're under extreme extenuating circumstances, facing foreclosure, have to obtain a loan, and they're worried about cash flow problems. And the flip side can also happen, and of course all this is accentuated under the current crisis. One thing I would like to point out, and I don't know if this is happening more, but I have a suspicion it might be. And Gaëtan and Ben have actually briefly touched upon it, and it's the issue of ex parte motions. And actually, we have to consider this in two primary situations. The hardcore ex parte motion would be when you seek something even before the other party has received notice. That's very far, and of course, most institutions would not allow that. And that's my general view and reading of the SIAC rules would also be that as well. But some institutions under extenuating circumstances will allow that. The second more controversial one, of course, is after a party is aware of the EA application, but before they've responded, should an EA do something? And of course, I'm wondering how many times that has increased more under the crisis. And I faced this situation. And if the party has not had a chance to respond, they are aware, you have serious kind of due process concerns, and they haven't had a chance to present their case or to provide their views. And that's a serious issue. Whereas the other party, of course, it has a very urgent, magnified, augmented urgency situation. So I'm wondering if this situation is occurring more due to the crisis. And I'd love to hear from my colleagues if they have any thoughts on that as well.
Yeah, so if I could perhaps add just a few ideas. I completely agree that these kinds of sort of applications for preliminary orders on an ex parte basis are going to become more common. As a matter of fact, only last week we put in that case, it wasn't an application for an EA because I wasn't available. It was an application for urgent interim relief as soon as the tribunal was constituted. And we accompanied the application for the interim relief with an application for a TRO, because I think that's often what we're talking about, right? It's a temporary restraining order asking the tribunal to say, order a standstill, tell the other side not to do anything until you've had a proper opportunity to process the application for interim relief. And I think, you know, courts obviously have been very much disrupted by COVID, but even for arbitrators these days, there may be practical constraints on how quickly they can get on top of an application for interim relief. And in those cases, I think we will see increasingly in parallel an application for a TRO. And I think a lot of people would argue that issuing a TRO in that sense on an ex parte basis, as you say, not without the other party getting notice, but you know, before the other party has had an opportunity to comment on that application. I think a lot of people would say that's part of the inherent powers of a tribunal. I think hopefully in the case of the SIAC rules, I think paragraph 8 of Annex 1, at least as I read it, seems to expressly provide for that power when they say the EA may issue quote, preliminary orders that may be made pending any hearing, telephone or video conference, or written submissions by the parties. And I think that's very useful, particularly in the current environment. I think it's almost going to be systematic, this occurrence of TRO applications.
I can say I have issued that kind of, exactly that kind of order on exactly that basis in a very recent case. You know, there was a very urgent matter. You know, the emergency arbitrator is there to provide a stopgap between the issue and the constitution of the tribunal. And these preliminary orders, I think, are there to provide coverage for that gap between the time that the emergency arbitrator is appointed and can actually hear from the parties and decide the matter. And so, yeah, it's exactly that. It's a TRO or a standstill order. You simply cannot sometimes decide even the emergency application in the time that is left before, for example, a letter of credit expires or a call option, or, you know. And so I think that's a very useful tool to have explicitly provided in the rules at paragraph 8 of Schedule 1. And the way I read it, it can even be made on the emergency arbitrator's own initiative. So I think we will see more of this kind of thing again, increasing under the current circumstances. So I agree with both of my colleagues on that.
Right. So we have touched and discussed a bit on, you know, ex parte, where, you know, the respondent is perhaps not participating yet. And I think it's always challenging when you talk about a non-responding respondent or an intermittently responding respondent. But, you know, in the times of COVID-19, what do you do if a party tells you that they would like to participate, but they could not, you know, for whatever reason, they don't have the technological means? From a due process standpoint, what can an emergency arbitrator do to ensure due process in the times of COVID-19? Perhaps, Ben, you can take the lead on this question.
All right. Well, I mean, it's always difficult when you have a respondent that either cannot or will not participate in the arbitration. And I think that is, you know, even more the case in the context of an emergency arbitration, because you don't have the time to do some of the things that you would do as a precaution in a normal proceeding. And this can be amplified in the context of COVID. I think, you know, obviously you have to make every effort to include the respondent and give that respondent every opportunity to participate in the proceedings. But you also have to get on with it. You have the 14 days, and that's what you're working with. And I think, fortunately, emergency arbitrator proceedings has been sort of ahead of the curve on all of this, you know, teleconference and video conference proceedings. You know, in spite of COVID, everyone has a telephone, and, you know, even if they can't get on a good Wi-Fi connection to have a video conference, you know, the norm has been that these hearings have been taking place primarily by telephone anyway. The issues that are being aired are usually of the nature that can be dealt with by the written submissions and perhaps a telephone hearing. You have to make sure that you know, you give the respondent every opportunity to participate. If the respondent is simply unable to get online and do a video conference, then I think you may resort to telephone. But I don't think COVID is an excuse for not having access to a telephone. I mean, there are issues that will arise, and we all have to be understanding of that and accommodating to that. It may take parties longer to prepare their submissions because they may not have access to the people or the documents. And to the extent that we can be flexible, I think that's very important. And just as an aside, I would say that, you know, electing not to participate in a proceeding because you think you can maybe challenge it later or you know, boycott it, and somehow that will be a productive strategy is a really terrible idea. And so I would encourage those who may be considering that to participate, because the process will go forward with or without you. And it's very difficult after the fact when you've been given all the opportunities to participate and simply did not. It's very difficult to argue that there was some due process problem that prevented you from presenting your case.
Okay, thanks very much, Ben. I do have a follow-up question, which I will ask Joongi in relation to what you've just said. But before that, we have a question from the attendees for Gaëtan. What factors should a party consider before making an EA application, and whether these factors are now influenced by the COVID-19 situation? What are the practical or preparatory steps, if any?
I'm not quite sure it's radically different now than it used to be. I mean, you obviously want to make sure that you've got all the systems ready to go. You want to make things as easy as possible for both the emergency arbitrator and the other side in terms of accessing all of the relevant materials. So in terms of the logistics behind that, you want to make sure there's a properly working upload link and all of that. But I'm not sure that there's a great deal of difference now as compared to before COVID, because already before COVID, you wanted to make sure that the EA was in a position to access and digest as quickly and as easily as possible the materials you wanted him or her to read, and that remains true now. Everything before COVID, when it came to EA applications, involved a lot of electronic files. Obviously, that's further amplified now in the COVID era. But again, I don't think there's a huge difference in that sense, at least in my experience.
Right.
One thing I think.
Yeah. Yes, Ben. Go ahead. Sorry. Please go ahead.
One thing that might be slightly different in the context of COVID when you're preparing to file an EA application is just for the parties to consider whether the relief that they are seeking, especially if it's some action that they want the parties to take or some continuance of performance, is to really consider whether that is really possible under the current situation, and then how that affects for the emergency arbitrator, how that might affect the balance of harms test. It's not so much that the process is different, but maybe your considerations might be slightly altered by the current circumstances. Because the emergency arbitrator is going to have to consider in assessing the prima facie merits of the case, whether what you're asking for is going to impose a burden, including potentially impossibility, and this gets into obviously force majeure issues, but it may affect how you prepare your case or whether you file the application.
Yeah, I would certainly agree with that. It goes beyond the practicalities that I was addressing. I think COVID does require you to take into account the consequences of COVID when actually assessing the likelihood of success of your application. Absolutely.
Yeah.
And then from the SIAC, we ask this, typically in all situations, but I think especially more so now in the COVID-19 times, to just give us a heads up if you're going to be filing an EA application with us, so that we have counsel ready to administer your case. Now, going back to what Ben said earlier, now you mentioned, do participate, with regard to the respondents, do participate. So my follow-up question actually is for Joongi. What then should a prudent respondent do in times of COVID-19 when it is served with an EA application? What are the immediate steps that should be taken?
Yeah, I guess it's kind of on the similar lines of what Gaëtan suggests. I don't know how much this is going to be really different in the COVID context, but I think, of course, usually when an EA application is coming, the party that receives the application usually should have a sense that somehow relations aren't that hunky-dory with the other side, that things are deteriorating, and something's going to happen. So usually the other side, that party that receives the EA application, should have a sense that something's going to happen. They probably might expect just a request for arbitration, but if that's in, they're going to factor that in, they should then take the next step to consider, actually they might even file an EA, and that might be highlighted or magnified in the COVID context. And of course, as prudent responding party, I think, as Ben just emphasized, the critical thing is participate and respond. So a lot of times the EA application will come in, it will go to the parties. The parties might be traveling, they might be in different locations, they may have a lockdown in Portugal, Chile, and Ireland, particularly in this situation, and it might be much more difficult for the parties then to engage counsel. And of course, that's the first thing that they should do. And they might not have counsel already in place. Ideally, they should hire experienced counsel. My view is it's probably wise to hire experienced counsel probably within the same time zone because of the time sensitivity. If you have someone in a different time zone, I think that's going to complicate things much more significantly. And I guess those are some of the critical issues that are magnified under our current crisis.
Gaëtan, Ben, do we have other views on this, or do you agree with what Joongi has just said?
I agree. I have nothing to add to it.
Right. So now that we know what parties must do, especially in relation to EA proceedings and in times of COVID-19, I really want to know, what is it like for an EA? What is the get-up process like? Does this operate differently during the COVID-19? Ben, perhaps again, you can shed light on this.
Well, I mean, I think it's pretty much the same, because emergency arbitration has always been a very fast-paced proceeding. You get the documents, you read them, and you try to get the parties on board with the schedule as quickly as you can. I really enjoy them because you have to digest these issues very quickly and come up with a solution. And I think that doesn't change in the COVID era. If anything, maybe the process is a bit intensified, which some people may not enjoy, but I actually, find this kind of thing very, very, very fun to do. I think this is a high stress environment for the counsel, and in particular for the junior lawyers who are frantically trying to throw the case together, under the cruel dominance of the partners. And this is one reason why I think it's very important to keep a cool head. So everyone involved in the process should just remain polite, professional, cool, and collected. It's a difficult process for everyone for 2 weeks, but you come out on the other end with at least some solution to the immediate issue that was before you, and then you go to the main arbitration with hopefully a clearer picture of how things are going to proceed. So I think with COVID, it doesn't really change. It may be a matter of degree.
Now, well, I'm looking at Joongi now because I know that he's recently appointed as an emergency arbitrator after the COVID-19 breakout. So, Joongi, would you have anything to add?
Cool, polite, professional. I have to totally agree with that.
I can add that, you know, I think I've had one post-COVID emergency arbitration, and the parties on both sides were extremely professional and polite, and were able to come to a consent order as to what the emergency relief order should be, what the EA order should be. You know, that saves everyone a lot of time, a lot of stress, a lot of headache. And at the end of the day, solve the problem, I think, from both sides' perspective. Now they're moving forward. I'm out of it now, but I assume they're moving forward with the case. And I think, you know, to the extent that people can, you know, keep in mind, of course, you have a dispute about the merits of the case, but right now you need to very urgently deal with the procedural matter of this emergency relief, and you need to get through it with as few scars as possible. And I think it's to everyone's benefit to try to look at the case, look at this application from the arbitrator's perspective and see what would be a reasonable result if you're standing in those shoes, and maybe confer with the other side about where you can and cannot accommodate each other.
Pauline, if I may, I have a question I'd like to pose to everyone. And I'm curious as to SIAC's experience as well. We know that, of course, theoretically, an EA with the party's consent could later serve as an arbitrator on the tribunal. And I'm wondering how often that happens, and do you think that's more likely or less likely to happen after COVID?
I don't know if anyone here has, the experience of being appointed as an EA and subsequently as the tribunal. I've not seen it in my 3 years with the SIAC and with all the EA cases that I've run. Under the SIAC rules, we do have a provision to say that the emergency arbitrator should not act as the tribunal thereafter. But again, I think with arbitration, it's party autonomy, and so if the parties agree, the institution would obviously do what it can to uphold that.
I mean, I would think that this would only work in the context of a sole arbitrator or as chair, because you wouldn't want to be one side party appointed arbitrator. And I think there's might be some reluctance on the part of the parties to agree. I mean, except in the case where there may have been a consent order where, you know, the parties were able to agree on the result.
That's
but
what
I think in
thought.
typical cases, I think in typical cases, one party will have not been successful and would probably be somewhat reluctant because the emergency arbitrator has already at least made a prima facie determination on the merits of the case. And so I would expect that would be somewhat rare for the parties to agree on that person to be the chair or sole arbitrator. But
I was just thinking that given that someone like Ben is so wise and competent, it might happen more likely.
I think my connection is going dead. I've got it.
All right, everyone, we do have, we have 2 minutes left, and just one final question to wrap things up. I think we mentioned, stay polite, stay professional. Any advice on, online etiquette during the COVID-19, where stakes are high and timelines are short? Should we be using a slightly off-white background like as we have now, or do we want a floral and beautiful background? Any thoughts, anyone?
So don't use wildly inappropriate virtual backgrounds. I don't know.
I think you know, people just need to be mindful of the circumstances, and you know that may require adjustment in the way in which you write an email. Perhaps, you know, I'm a big believer in courtesy in any circumstances, but I do think there's a heightened awareness, and people generally will take that into account when written communications to each other.
And don't show up for a video conference in your pajamas.
Right, so that brings us to the end of today's session. A big thank you to all our panelists for your time and for sharing your, your views. Those are very, very insightful views. Thank you as well to all our viewers for joining us today. Don't forget to join us again, same time this Thursday for our next session. Thank you very much, everyone. Take care and keep safe.
Take care.
Thank you.